Hi everyone. Today we have a topic of restraint of trade. I'd like to refer you back to week 6 where there are some notes on restraint of trade, so I thought rather than repeat this and material that's in the books of readings, and incidentally there are still some books of readings in industrial relations and sport available from my office, and I strongly urge those of you who haven't seen them, looked at them, picked them up to come and get some. Yes, they're dated about 5 years, but they also cost students then about $30 to $40, and they're free to you because they still have articles which raise relevant questions, relevant ways of looking at employment relations in sport, industrial relations in sport, and especially professional sport matters such as player associations. So what I want to do is take a case study, if you like, or an example of restraint on trade which has become famous in Australian sporting, sport law and industrial relations and sport circles. This concerns Kim Hughes, who was Australian cricket captain and who ended up taking a restraint of trade law case against the Western Australia Cricket Association, and I'll just give you a little bit of background and then take to a couple of academic articles to talk about it. From this book, Golden Boy, which is about Hughes and his life, Allen and Unwin, I think it's last year, 2009, page 277, quote, this after a rebel tour, so-called, of cricketers to South Africa at a time when there were still aspects of apartheid, when there were racial attitudes there, when Australians were not condoning sport contact with South Africa necessarily, and when players who weren't picked for the Australian team felt that to keep their livelihood and also for a range of other personal matters, they would undertake a tour called a rebel tour to South Africa. So when he came back, quote, could runs bring forgiveness? Some of Kim's colleagues were indignant. They had resisted South Africa's loot, anticipating a life ban, not a feather duster, for punishment, that is, for going on the rebel tour, quote unquote. Traditionalists resented Kim for depleting Australia's playing stocks. When WACA, Western Australia Cricket Association, committee men moved to outlaw the rebels from club cricket, General Manager John Rogers urged, quote, don't pursue Kim, you're missing the feeling of the whole Western Australian public who absolutely adore him. Pursue him they did, a chase which ended up in the federal court, where Kim alleged a conspiracy against him and a restraint of his trade and won the matter. The WACA lost several $100,000 on court costs and, it seems, any lingering inclination to see Kim ever again. Now, to amplify that in a legal context, we have Restraint of Trade in Australia's Sport by Sam Chadwick, published by ePublications at Bond, 2010. Quote, page 12. In Hughes, a rule prohibiting a player from participating in a game not recognised or authorised by the Australian Cricket Board or the WACA was deemed to constitute an understanding for the purposes of the TPA. 2EJ stated that for the roles of an organisation to constitute a contract, as between its members, as opposed to an understanding, there must have existed an intention that the rules should give rise to enforceable legal relations. The rules in question were typical of a sporting legal federation. Ordinarily, athletes don't negotiate or sign such rules and regulations, but agree to adhere to them. And related to that, and make it Annette Greenhow, or Greenhow, the
quote, page 4, in Hughes present, cricketer Kim Hughes argued that these sections of the Act had been breached as amounting to a restraint in trade. That's sections 45, part 2, A and B, of the Trade Practices Act 1974, often referred to, as in the previous article, as the TPA. So the Trade Practices Act 1974.
So Hughes argued that these sections of the Act had been breached and amounted to a restraint of trade. The trading corporation requirement was considered in Hughes in promoting and controlling cricket in Western Australia. The W, a complex and sophisticated organisation receiving and dispersing large sums of money, forever expanding the scope of its activities beyond cricket to other forms of entertainment, and generally engaging in activities that were of a trading nature. By any test, these activities were substantial. So here we have this organisation, substantial organisation, akin to a corporation in trade. Hughes said, look, you're banning me from club cricket, cricket is my trade, and the WACA doing that were found to be guilty of imposing restraints of trade, of restraining Kim Hughes being able to play cricket, which was his chosen career at that particular time. So in the example, in summary, we have Hughes undertaking 2 cricket tours of South Africa, 1985-86, 1986-87. The Western Australia Cricket Association attempted to ban him from club cricket. In response, he took the action against the WACA for restraint of trade. He won the case in the Federal Court of Australia. The WACA allegedly lost several $100,000 in court costs. So that then illustrates professional sportsman, restraint of trade, and how that could apply and how it could not apply to particular circumstances. So it's a case that's important in Australian sport and illustrative, in a similar way as the Bosman case is important in world sport and particularly European sport for restraint of trade under the European Union rules. So go back to week 6, have a look there, and just have a simple understanding of restraint of trade and how it can apply particularly in professional sport.